Hi friends, hope all are doing good. We have already completed the two organs of government, legislature as well as executive. Now it's time to look at the next organ, that is judiciary. You know the functions of all the organs of the government, right? Legislature is the law-making body, executive is the body that implements the law or implements the policies of the government, and judiciary, the third organ, that's the interpreter and protector of the constitution, or we can say interpreter and protector of the laws. Okay, yeah, so these are the important topics we are going to look at. Why do we need an independent judiciary, structure of the judiciary, judicial activism, judiciary and rights, judiciary and the parliament. Of course, judiciary is a very important organ of the government because of its independence, right? So let's start with why do we need an independent judiciary? Of course, we know judiciary is independent of legislature as well as executive, right? They cannot interfere. Legislature or executive cannot interfere the functioning of judiciary. That's a key point, right? Yes. So the main purpose or the main function of judiciary is dispute settling, right? Dispute settling by an independent body with rule of law. What is rule of law then? Rule of law means all individuals, rich or poor, independent of rich or poor, men or women, irrespective of men or women, forward or backward class or caste, are subjected to the same law. We all are subjected to the same law here in India. That is what rule of law is. Okay, whether it is rich or poor, whether it is men or women, whether it is forward class or backward class or forward caste or backward caste, it is nothing matters. We all follow, or we all have to follow rule of law. That is the same law, right? We all are subjected to the same law. Then protect rule of law and ensure supremacy of law. That is one of the functions of judiciary. It protect rule of law and ensure the supremacy of law. Judiciary is the organ of the government that ensures the supremacy of law, right? Then it safeguards the right of individuals, settle disputes, and ensures democracy doesn't give way to dictatorship. What is that? Ensures democracy does not give way to dictatorship. Judiciary has control over other organs. That's another key point. Judiciary always have or has control over the other organs, executive and legislature, to some extent. Okay, yeah. Then independence of political pressures. Of course, judiciary works independently, so we can say it is independent of political pressures. If there is political pressure, what happens? Their judgment may vary, right? So it may lead to some complex situations, complex scenarios, right? Yes. So there must always be independence in judiciary. So these are the points. Okay, yeah. Then independence of judiciary in detail. Other organs must not restrain the function of judiciary. Of course, executive or legislature must not restrain the function of judiciary, and they should not interfere with the decision of judiciary. That is, decision of judiciary is final. Executive or legislature cannot interfere in the decision making process of judiciary, right? Because it works independently. Constitution provides, or constitution has provision in independent working of what judiciary. Okay, then judges must be able to perform functions without fear or favor. Judiciary is accountable to the constitution. Judiciary is only accountable to the constitution, or we can say judiciary is accountable to the people of India. Constitution, in other words, we can say people of India, right? So judiciary is always accountable to the constitution or people of India. How these are protected? Next question is how these are protected. Legislature is not involved in the appointment of judges. Yeah, legislature is not involved in the appointment of judges, but executive has some role in appointing judges. Okay, the judges have fixed tenure. Of course, executive or legislature cannot interfere in the setting or fixing up the tenure of judges. It is defined in the constitution. Okay, it is secured by the constitution. It's secured by the constitution. So judges have fixed tenure. Then judiciary is financially independent. Judiciary is financially independent. All these are given in the constitution. So constitution has provision in all this protection. Okay, protection of judiciary. Then contempt of court, power to penalize any person. It's an effective tool for protection from unfair criticism. Actually, there are two types of contempt of court: civil contempt of court and criminal contempt of court. Okay, you know civil and criminal. What is civil? What is civil? Civil means private dispute between persons or organizations. Okay, but criminal is harm to the society, just like murder, right, or some other kind of actions that harm to the society or harmful to the society. So contempt of court is a very effective tool to stop or to protect judiciary from unfair criticisms. Unfair criticisms. Okay, we can have means we can have our own views on judgment, but it must not go unfair. It must not go unfair, or it must not affect the purity of the judiciary. Okay, yeah. So court has power to contempt. Okay, yeah. Then appointment of judges, CJI, Chief Justice of India, appointed by the President. Then other judges of Supreme Court and High Court are appointed after consulting with CJI, Chief Justice of India. Then CJI should recommend the names of the person to be appointed in consultation with 4 senior most judges of the court. It's called principle of collegiality. You might have heard of collegium, right? Supreme Court collegium, yeah. So this is the composition of collegium. So here Supreme Court or judiciary has major power over executive. Okay, executive has some power on appointment of judges, but here also the upper hand is with judiciary. Okay, yeah. Then removal of judges. Okay, we have already seen appointment of judges. Then about removal of judges, judge of Supreme Court or High Court can remove only on the ground of proven misbehavior or incapacity. These are the 2 grounds on which the judge of a Supreme Court or High Court can be removed from his office. That is misbehavior or incapacity of being in the position, right? Yes. Then special majority is needed in both the houses. You know what special majority is? Okay. Then appointment, executive play a crucial role, but in removal, legislature plays a crucial role, right? How? In the appointment of judges, along with the collegium, the executive also play some role, but in the removal, Parliament does it, right? Parliament does the removal of judges, but it requires what? Special majority, right? Special majority is needed for removing judges of Supreme Court or High Court, and the only criteria must be, the only ground on which they can be removed is misbehavior or incapacity. Okay. Actually, there was an incident back in 1970s. One judge was trialed, but he could the Parliament couldn't make him remove because what to say, they got 2/3 of majority, but the total number of the majority of total number of members of the Parliament it was failed. So he came back in the position that it was failed. That's it. Okay. Yeah. Then structure of the judiciary. Single. Okay, we know the structure of judiciary in India. It's a single integrated system. Okay. We can see a lot of courts like Supreme Court, High Court, then district courts and subordinate courts, but it's under a single system. That is a unitary system, single integrated system with Supreme Court at the top, High Court below them, and district and subordinate courts at the lowest level. Let's see some of the functions or some of the features of all these courts. Supreme Court, of course, we know that's the highest court of appeal. That's the topmost court, right? Supreme Court is decisions are binding on all courts. Decisions of Supreme Court are binding on all courts. All courts like High Court, District Court and Subordinate Court. Then transfer of judges of High Court can be done by Supreme Court. Okay, and there are some other functions as well. You can just refer to your textbook. Okay, then High Court, here appeal from lower courts like District Court or Subordinate Courts. Then they can issue writs. You know what writs are? Writs are the what means by which Supreme Court or High Court can can protect the fundamental rights of the people, right? Can enforce the fundamental rights of the people in case the fundamental rights are violated, right? And Article 32 provides Supreme Court to go with writ, and Article 226 gives the power to High Court to go with writ. Okay, writs. And which are the writs? We have already seen it, right? In fundamental rights, yes, Article 32, fundamental constitutional remedies, right? Yes, we have habeas corpus, mandamus, prohibition, then quo warranto, certiorari. These are the 5 writs, right? Yeah. Then district court, cases in a district. They can handle cases in a district. Subordinate court, case of civil and criminal. We have already seen what civil and criminal are, right? Yes. So subordinate court can hear civil cases as well as criminal cases. That's the lowest level of this hierarchy. Okay. Yeah. Hope you understood the structure of the judiciary in India. Then jurisdiction of Supreme Court. You know, Supreme Court is the topmost court in India, and it has several jurisdictions. In other sense, we can say it has several powers. Functions and responsibilities are defined by the Constitution. Okay, functions and responsibilities of Supreme Court are defined by the Constitution, and these are some of the jurisdictions: original, writ, appellate, and advisory. Let's see one by one. And original? What is original? Cases that are directly considered by the Supreme Court. That means no other court can consider that kind of cases or those kind of cases, like cases that matters in federal relations, like union and states, central and states, like water disputes or some other territorial disputes. Okay, yes, boundary disputes. Yeah, not territorial, boundary disputes. So those cases can be considered only by the Supreme Court. That's what original jurisdiction is. That means only Supreme Court can hear those cases. That's the very meaning of it. Okay. Then writ jurisdiction. You know what writ is? Just for restoring fundamental rights. If fundamental rights are violated. Okay. Yes. Both Supreme Court and High Court can issue writs. Then appellate jurisdiction. Appellate. Highest court of appeal. That means it can reconsider the case. What is that? Suppose one failed in High Court in this case, and if only if High Court permits for appealing in the High Court or in the higher court, that is Supreme Court, the person can approach the Supreme Court. Hope you understood the logic, right? Even if the High Court or any other court, okay, let's consider High Court. Even if the High Court reject or give some the order that the person doesn't wish, he can approach the Supreme Court only if High Court permits for appeal. Okay, yes. So at the time he can the Supreme Court can reconsider the case. Okay, yes. Then advisory jurisdiction. Advisory, that means President can refer any matter. Interpretation of Constitution is another function. That means in the case of any public matter or publicly affecting matters, President can refer to the Supreme Court. Okay, and Supreme Court, it is not binding. Actually, Supreme Court is not bound to advise the President. And even if the Supreme Court gives advice to the President, President is not binding on the advice. Okay, neither the Supreme Court nor the neither the Supreme Court nor the President is binding on the advice. That's very logic. Okay, yes, but President can ask for the advice. Decision made by Supreme Court are binding on all other courts in India. We know that, right? If any decision is made by the Supreme Court, if similar cases come in High Court or other courts, the reference is Supreme Court judgment, right? Yes. Then judicial activism. Sorry, there is a spelling mistake. It is judicial activism. What is judicial activism? You might have heard of public interest litigation, right? PIL, or social activism litigation. Okay, there is one more name, or judicial activism. Actually, judicial activism and public interest litigation both are not same. Public interest litigation is a tool to implement judicial activism. Okay, or it is a vehicle through which judicial activism is being implemented. Hope you get it. Yeah. Revolutionized the function of judiciary and made it more people friendly. And usually, okay, PAL is the chief instrument through which judicial activism has flourished. This is the chief instrument. That PAL is the chief instrument through which we can implement judicial activism, or judicial activism is flourished or has flourished. Okay. Normally, an individual can approach a court only if he or she has been personally aggrieved. Usually, what happens is, if I got some problem, I do go directly because I am the aggrieved person, right? Yes. So normally an individual can approach a court only if he or she has been personally, by him or her, personally aggrieved. But in the case of judicial activism, or with the help of public interest litigation, someone else can also approach the court. Okay. In usual cases, we have to approach the court directly. We have to produce ourselves before the court. But in the case of public interest litigation, someone else can appear or can file a complaint or petition on behalf of us or me or someone else. Okay. So PAL case is not filed by the aggrieved person, but by some other person on his behalf or on her behalf. Okay. Yes. PAL is the most important vehicle of judicial activism. We have seen judicial activism is one of the most, or one of the finest tools available in India. Actually, it is not mentioned anywhere in the constitution, but it was a gradual process. Okay. Indian constitution is a living constitution. By the way, got many amendments and many interpretations to the constitution. Okay. So it was a gradual process in which judicial activism came in Indian judicial scenario. Okay. Yes. So it's a most important vehicle of judicial activism. Hope you understood the logic, right? Yes. It made the judiciary more friendly, more pupil friendly. Yes. Then judiciary and rights. It can restore the fundamental rights by issuing writs. We know that. It can declare a concerned law as unconstitutional. Of course, writs, restoring the fundamental rights if it's getting violated, unconstitutional. It is a very right of the Supreme Court, or the judiciary, to interpret the constitution, right? We have seen so many interpretations so far. So Supreme Court or the judiciary has the very right to interpret the constitution, or the rights, we can say, or the laws. Okay. Protector of fundamental rights and interpreter of the constitution. We know that. Interpreter, protector of the constitution. Most important power of Supreme Court is judicial review. It examines the constitutionality of any law. Yes, of course we know that. Judicial review. Written review powers make judiciary very powerful. Okay. These are two important tools that make judiciary most powerful. That is written review. Writ and judicial review. It can review a case. Okay. Even if it is ended, it can review, and it can make its own interpretation on it. Right? Yes. Then judiciary and parliament. It can give directions to the executive agencies like CBI. It can directly give. That means it can directly give directions, or it can give directions to the executive agencies like CBI, Central Bureau of Investigation, for investigating cases of politicians or bureaucrats on corruptions and some related cases. Yeah. Constitution is based on the principle of limited separation of powers and checks and balances. Yeah. What is that? Checks and balances. Every organ of the government has a clear area functioning. Okay. These three organs of government, legislature, executive and judiciary, these are having their own area of functioning. Okay. One cannot interfere in the matter of other. Hope you get it. They have the clear boundary on which they can function. They cannot go beyond the boundary. Hope you understood the very logic of checks and balances, right? Yes. Then in the famous Keshavananda Bharati case in 1973, the Supreme Court has emphasized on basic structure doctrine. Even the Parliament cannot make modifications or cannot go with amendments that affect the basic structure doctrine. Basic structure doctrine is not defined anywhere in the Constitution. It was also built by the gradual process of this judiciary in India, right? Yeah. The conduct of judges cannot be discussed in the Parliament. Okay, the conduct of judges, the behavior of judges cannot be discussed in the Parliament. What all this show is checks and balances. All are having their own what area functioning, and they do what it limits their function within their area. They cannot go to another area and interfere in their working. It's not possible. Okay. Yes. So this is all about judiciary. Hope you understood this, all the topics, and I think it's a very important topic. Okay, of course, you can expect questions from this. This is a very dynamic what part of the Indian polity, of course, and as I'm always telling you, just prepare notes and always parallelly just refer to your Indian constitution work. Okay, have a good time and stay tuned for the coming videos. Okay, yeah, take care, bye.